Good afternoon. This is Maureen
Hold
Lemassney.
on 1 second. We're not.
Okay.
Yeah, we're still setting it. 1 second.
Good afternoon. This is Maureen.
Okay, we're good to go.
All right. Good afternoon, everyone. This is Maureen Lemassney, and welcome to the meeting of the Police Reform Work Group. I welcome not only our members, but also the public who are watching our proceedings. If you're joining us for the first time, our mission is to provide our County Executive Angela Alsobrooks with substantive recommendations that will establish fair practices across the board and restore public trust in law enforcement. We've established 5 committees who will begin meeting shortly. Our agenda tonight includes a presentation from the Internal Affairs Division of the Prince George's County Police Department and the State's Attorney's Office. Thank you all for joining us, and I'll turn it over now to Delegate Washington, the co-chair of the work group.
Thank you, Judge Lemassney, and good evening, everyone. It's great to have this meeting today. We're looking forward to a very fruitful discussion on policing and reform and possible reforms. As the judge mentioned, we will have 2 presentations today. For our members, how we're going to conduct our meeting today is we're going to allow the 2 presenters to present their presentations for 15 minutes straight, no interruptions, and then we'll take questions for about 30 minutes or so, so that everyone has an opportunity to have a dialogue or fruitful conversation about these things. I know working through Zoom is very difficult for us to really have a real dialogue, but we're going to try our best this time around from the last 3 meetings that we've hosted. So with that said, let's have Mr. Major McCrary from the Prince George's County Police Internal Affairs Division to start his presentation. Thank you, Major.
How are you? And I don't know if the presentation was sent over or how the PowerPoint was pulled up, or do I need to pull it up?
Yeah. Ryan, you got that? You got the presentation? Ryan or Miss?
I do not have the presentation.
Miss
Jonathan Jonathan Bender, do you have the presentation so we can share it on your screen?
Yeah, stand by, let me pull it up.
All right. And then while we're doing that, I know we went through the complaint process a little before. I brought the whole presentation this time, not just the flow chart. It's a lot of slides. I'm going to try to run through it as best I can. I know that everybody is going to have questions as I'm going, but we went through a lot of this before, so hopefully it rings some bells and we can try to get through it quickly. I know I only have 15 minutes and then we'll start with the questions, so I'll get through as much as I can and try not to dwell too much on each slide. But if I'm going too fast, slow me down and we'll go back.
No, definitely we will. Thank you.
Delegate Washington, is there anything specifically or to the group in my previous presentation or anything that you guys want me to focus on? Because I can always skip forward. I know we went through the.
No, I think the last presentation was a little rushed and fast, and I don't think a lot of us got any information from that one, honestly, except from the questions, if I'm being honest.
Okay.
So I would just take your time and go through it as much as you can.
Yeah, I'll get through as much as we can, and if you guys need me back, I'll be back.
You get one shot, man. That's it.
Okay, well.
I'm joking.
All right, well, I'm at the plate. I'm a swing.
All right.
Can you guys see it up now?
Yep, we got it.
Yes.
We can say it is not a full presentation.
Yeah.
Mr. Bender, can you make it a full presentation? Full slides? Or start the slideshow, probably is probably the best thing.
Yeah, I'm seeing it on my end as being full. Hold on.
There we go. Perfect.
All right. Again, good evening, everyone. I am Major James McCrary with the Prince George's County Police Department Internal Affairs Division. We've got the introductions while we were getting the PowerPoint up. So if we can go to the next slide. This was the flow chart that I went through before. We'll just go to the next one. You guys have seen that. It's complex and convoluted, but these slides will break down each step. Our mission, again, is to investigate all complaints thoroughly and impartially. We want to make sure that we're taking all complaints in all manners and all forms, and we want to impose our discipline in a fair and uniform fashion. We discussed before, we take complaints from a wide variety of sources. If we can go to the next slide. We'll take them written, we'll take them verbal, and we'll take them from our partners in the community, which include the NAACP, Casa de Maryland, several victim advocacy groups. We'll also take them from our partners within the government, from the State's Attorney's Office, the County Attorney's Office, CCOP, and the EEOC, which is the Equal Employment Opportunity Commission. If we can go to the next slide. All complaints, when they come through, regardless if they're in person, if they're verbal, or if they're written, come through our Internal Affairs Division. So if a complaint comes to the district and a person fills out our complaints against police practices form, or they send an email to the CCOP, that complaint comes over to the Internal Affairs Division. We screen the complaint, access it, and then we will generate case numbers for the field supervisors if it's sent to the field, or we will assign it to an internal affairs investigator. If we can go to the next slide. The way we break it down is when it comes over to internal affairs, there is a conversation between myself and primarily the captain and the two lieutenants at the administrative investigative section. They review the complaint, and what they determine is if it's a minor violation, something that's simple and non-complex, we reserve that for the supervisor on that level. If it's anything that's a criminal investigation or a serious administrative investigation where the discipline could be termination or reduction in rank, significant fines, our Internal Affairs Division will investigate it. We can go to the next slide, please. There are 4 things that Internal Affairs always investigates: complaints of criminal misconduct, use of force, abusive language, and harassment. Next slide, please. Why do we separate it in that manner? 3 primary reasons, but there's a wide variety. But we want to allow our supervisors to have impact on the officers that they're supervising. We want our supervisors to be mentors, and we want them to be aware of the development that the people that they supervise. Operationally, we want to allow internal affairs to focus on the serious investigations. Again, those criminal and serious administrative investigations. And probably the most important that we found is it allows our citizens to have a connection to a supervisor in their community. We found that if a supervisor is able to remedy an issue that a civilian has with one of the officers that work in their district, it allows that connection, and we have that community policing element where citizens are comfortable bringing not just officer misconduct complaints, but also crime prevention and things going on in the neighborhood directly to that supervisor because they have a name and a face to go with it. Slide, please. Some examples of things that were reserved for the supervisory investigations: failure to appear court, departmental accidents, minor courtesy violations, tardiness, again, courtesy violations, report writing issues. We'll see that a lot. We'll get citizens that'll complain and say that I'm at fault for for this accident, and I don't believe that was the case. And we allow our supervisors to impact that. Each of our supervisors have training and are well-versed in how to investigate these type of incidents. And they always have internal affairs. We get calls from supervisors all the time with questions on how they approach certain paperwork or interviews, anything of that manner. Please. Case assignment. The supervisory investigations are usually conducted by the lowest level, the lowest supervisory level, which is usually a sergeant. Sometimes it can be a lieutenant or above, but primarily it's investigated by a sergeant. The methods of investigation. Supervisors, again, these are simple, non-complex investigations, but they'll review and gather all the available information, body camera video, mobile cruiser video. They'll access interviews with witnesses, with officers. If there's surveillance video, they'll compile that. Once they complete their case, they'll amass all the evidence that they have in the investigation, and they'll write what's called a report of investigation, which summarizes all the investigative efforts that they had during the investigation. And then they'll begin to submit that for review. If we can go to the next slide. When they submit their report of investigation, they'll submit their findings as well. We went through these a little last time, and I know I went quickly, but there's 4 case findings that an administrative case will have. It's sustained, which is the officer was guilty based on the evidence that the investigator found. Non-sustained, the charge is inconclusive. We often see that when it's one person's word against another, like a he said, she said thing. Unfounded, we'll often see those. It says that the allegation doesn't occur, and we'll often find that in situations where we have body camera video or car video that shows that the allegation didn't transpire the way it was put into the complaint. Exonerated is the 4th case finding, and we usually get those in use of force. It says that the offense did occur, but it was justified. And again, we see those probably most often with our use of force investigations, that the officer used force, but it was within policy. We can go to the next slide. This is the review process, just a brief chart for it. As you can see, we try to get as many eyes, even on the supervisory investigations, as possible. The investigator will complete his investigation, then it'll go to the lieutenant who reviews it. At any point in this process, it can go back to the investigator for follow-up. It can go back for any proofreading, but if there's any investigative lead that's missed during this chain, it can go back to the investigator. Once it goes from the lieutenant, it will go to the captain, up to the major, to the deputy chief of that division or bureau, and then it comes back to internal affairs for review. We'll give the final review, and if there is a sustained charge, we will recommend the discipline. Once they have their recommended discipline or internal affairs clears the findings, it'll go back to the bureau for final discipline. Next slide, please. I touched on that. If sustained allegations, what we call a disciplinary action recommendation is drafted, and it'll be served to the officer by their commander or the designee. It's usually the investigator, which is the supervisor that drafted the case in the supervisory cases. Next slide. 2 options that an officer has when they're served with their discipline in an administrative case. They can accept the recommended discipline, or they can request an administrative hearing board. Next slide. An administrative hearing board, we touched on this before a little, but it's a quasi-judicial process, very similar to a criminal proceeding. The prosecution, which is usually from the county attorney's office, will represent the department in the case, and an officer will be represented by a defense attorney or a person of their choosing. They present evidence, they present testimony, everything that's in the case file, whether it's video, written statements, anything is presented to the board. It's recorded and it's open to the public. Next slide, please. At the conclusion of the hearing, they'll go over the evidence, determine if it was guilty or not guilty. There are 2 types of board, and I'll get to it in the next slide. The most common is the 3-person administrative hearing board. They don't have to be unanimous to have their decision. It just has to be 2 out of 3 votes. There are instances where there is a one-person board, but the next slide should denote that for us. Again, the most common that we see is the 3-member panel. It's chaired by a major, the co-chair is a captain, and the third person is a rotating member of equal rank. The respondent has 4 alternatives that they can pick from, and we usually allow them to strike people that may have conflicts of interest in the case. Slide, please. The 1-member hearing board is reserved for these specific type of charges. It has to be $150 fine or less than 3 days suspension to have a 1-person hearing board. It's usually chaired by a captain. Our hearing boards currently do not rotate. Our chair, that is a major, is a person that's been trained and experienced in running the hearing board, as well as the co-chair captain. One of the unique differences between our administrative hearing boards and a court judicial criminal proceeding is that the hearing board's burden of proof is preponderance of the evidence. So if it's on a scale of 100, it's 51% likely that the person committed this offense. And that's also the standard in our internal affairs investigations on the administrative side. Next slide, please. Once there is a finding of the charges and they're guilty, the board will draft a what's called a board report. They'll submit it to the chief with their conclusions and summarizing the proceedings and how they arrived at their conclusion. The chief has 30 days to respond with the findings. After the review, they come back to the to the officer at another point for them to sign. If we can go to the next slide. During that point, the respondent does have 5 days to request leniency to the board. Oftentimes, they'll present character witnesses that can attest to the person's character and that this is outside of the scope of their normal behavior. The board will hear those cases. The respondent can also present to the chief as well. Again, just like the formal hearing, these character hearings or witness hearings are also recorded. Next. Again, once they get their final discipline and they sign it, it becomes in effect the moment that they sign, but they do have the opportunity within 30 days to appeal. If the circuit court reviews the case and determines that there was an error in the judgment of the board, the person would get the punishment back retroactively. So if they were terminated, they'd be immediately terminated when they signed. And once the circuit court ruled, they would be retroactively placed back to work. Next slide, please. All right, that is the supervisory side. Again, once it goes down to final discipline, it's enacted. I'm going to jump over to internal affairs investigations. Thank you. Again, the 4 things that internal affairs will always investigate. Next slide, please. The Internal Affairs Division is broke up into 2 sections.
Major, can you go back to the slide before this one, the previous one?
Yep.
And then can you just walk us through just systematically on this slide how it would work, just so as we are looking at it for the internal affairs portion of it? Can you just pinpoint how it will work? Just go through it real quick for us.
Real quick, okay.
And then you can go through your other slides.
Yeah, not a problem. So on the left-hand side, you'll see once a complaint comes in at the top, we'll review, determine if it is a supervisor investigation or an internal affairs investigation. If it's something that internal affairs is going to investigate, we'll keep it. It'll either be broken down into, if it's a criminal allegation, use of force, departmental shooting, any of the serious offenses go to our special investigative response team. If it's strictly an administrative, but a serious administrative investigation, it goes to our administrative investigation section. Once it's been assigned and the case is complete, it goes up the chain, and there's this very similar review process to the supervisory side. We try to get as many eyes as we can on these investigations. It goes through the chain of command. It differs from the supervisory side slightly. And there's two things that can change with it. If it's a suspension or a fine, myself in conjunction with the chief of police will make the final recommendation for discipline on sustained findings. And then it will go from myself to the Citizen Complaint Oversight Panel, who will conduct their impartial review of the investigation. And then it takes a similar junction to the other side, where they can either accept their discipline or they can go to a hearing board. If we go back up to the square at the top left, if it's not suspension or fine, if it's termination or reduction in rank, what takes place is another set of eyes get to see it. And we have what's called an executive command staff review. And that includes the chief of police, the assistant chief of police, the 4 deputies, the chief of staff, and Inspector General Mr. Turner is there for legal advice. And what takes place there is I will take the entire case file to the executive commanders, and I will go through everything that's in the case file, allow them to review it. At that point as well, it can go back to the investigator. They can do follow-up investigations. They'll ask questions, they'll review all the statements, they'll look at video, and they'll come to a determination where they vote and decide if they are going to go with the recommended sustained finding from internal affairs or if they're not. And again, those are only for termination and reduction in rank. Then it goes to the Citizen Complaint Oversight Panel, to the officer for discipline. And if they accept it, the discipline's final, or they can take the hearing board to final discipline. And then we can go to the next slide that kind of breaks down everything I just discussed. Again, here are the 4 things that internal affairs will always investigate. Next slide, please. This is the breakdown of the sections. Again, the Special Investigative Response Team does all criminal misconduct, firearms discharges, in custody deaths, serious use of force. And we include serious use of force anytime where a person's hospitalized, a bone is broken, loss of consciousness. We send an investigator out to the scene to assess the scene and begin an internal affairs investigation. And the unique thing about that is I believe we're the only police department in the state of Maryland that has that facet that responds to every serious use of force. And the administrative investigation section does the complex administrative investigations, serious discipline, fines, suspensions, reduction in rank, and termination. Next slide, please. The investigative methods, it's very similar to criminal investigations because we actually do conduct criminal investigations. We're looking at forensic evidence, so ballistics, DNA, cellular data. We're getting call records. We're getting financial records, depending on the case, video, body cameras, officer interviews. Every case is unique, but whatever evidence is available, we're going to look into it and assess it and make sure that we're looking at the case thoroughly. Slide, please. Law Enforcement Officer Bill of Rights. I know a couple questions about this came up before. What the Law Enforcement Officer Bill of Rights is, or LEOBR, is it's a state legislature that seeks to provide due process for our officers. Establishes guidelines that Internal Affairs follows with interviews and interrogations, how to conduct our hearing boards, and time limits for administrative charges, which is 1 year from when the department became knowledgeable of the incident, or after, in a criminal situation, after the criminal portion of the investigation is complete. So if the state's attorney issues a decline to prosecute letter, or once the court process is adjudicated, that day would start from there. Slide, please. One of the good things about the Law Enforcement Officer Bill of Rights is it mandates that an officer provides us a statement in the administrative investigations. If it was just a criminal proceeding, they could take their Fifth Amendment right and never speak to us and give a statement. To get that statement, we allow the officer 5 days to obtain counsel. In most cases, we don't have the evidence we need to investigate within 5 days anyway, so that gives us the amount of time we need to prepare to make sure that we have everything available to ask them. So we can look at the body camera and make sure we know what's there. We can talk to witnesses. We can canvass for surveillance. Next slide, please. Before I get into criminal investigations, the one other benefit that assists us with the Law Enforcement Bill of Rights is, I don't know if you guys have seen nationally, but there are instances where officers are terminated, and it's probably for just cause, but because they appeal, they get their jobs back because there was a violation of due process. Law Enforcement Officer Bill of Rights establishes due process, and in most occasions, I haven't seen one yet in my tenure here that it's been appealed and the person was put back, and that's because we have such a stringent procedure that we have to follow. Criminal investigations are worked in conjunction with the State's Attorney's Office. Myself and Captain David Robinson, it's on the Special Investigative Response Team, or CERT, and Captain Watson, who's with AIS, also is constantly in contact with the State's Attorney's Office. We have a good relationship with Ms. Renee Joy, who will be presenting after us. LEOBR doesn't apply during the criminal phase. It only applies to the administrative portion. So if an officer wants to take that Fifth Amendment right in the criminal phase, they can, and a lot of times they do. Next slide, please. Again, once the criminal investigation is complete, the internal affairs investigator will conduct a separate independent internal investigation. And that usually starts when we get the decline to prosecute letter, or in the instances that it goes to court and the person is indicted or charged, it will begin once the court proceeding is over. On Miranda. Again, we work in conjunction with the State's Attorney's Office. A lot of times with Miranda, we want to make sure that we're not in any violations. So we'll often go back and forth with the State's Attorney's Office just to bounce ideas off of each other to determine if Miranda is necessary and at what point we try to issue the Miranda rights. Next slide. And this is the reason. The Garrity Rule, it is based on a court proceeding, Garrity versus New York, that went to the Supreme Court in 1967. And it ruled that an officer can't sacrifice their right to incrimination in order to retain their jobs. So if we try to get an administrative interview, an officer could potentially feel that they were compelled to give that statement because we're internal affairs, and it would be a violation of their Fifth Amendment rights. So we often make sure that we tread lightly. And again, we work with Ms. Joy and the folks at the State's Attorney's Office to make sure that we aren't in any violation of that. Next slide, please. Again, there's a similar process. We try to get as many eyes as possible on each of our investigations. It goes from the investigator to the lieutenant, captain to the major, and then it goes to final discipline or Roman vote. And there actually should be a couple points in there for the criminal investigation. Of course, the State's Attorney's Office provides eyes on it, and also it goes to the Citizen Complaint Oversight Panel. One of the things that we have talked about, Captain Robinson and myself and Ms. Joy, is trying to find an appropriate way to screen the use of force investigations with them. We run past anything that is serious or is criminal on its face, but we're trying to loop them in earlier on in the process. There are over 800 use of force reviews. And I know Renee and Mr. Eubanks work hard, but we don't want to inundate them with too many cases. So we're trying to find a way to give them the appropriate level of use of force investigations that are serious. And I think, and Renee can correct me if I'm wrong, and Captain Robinson's here, but I think maybe the serious use of force that the investigators go out on, the broken bones, loss of consciousness, we may just start sending the executive summaries or the reports that are drafted on the scene to the State's Attorney's Office so they're aware. And another thing that we found was anything that's serious in the media, something that pops up on social media, a video, anything like that, we're trying to make sure that we make notification in this process, again, just to have as much impartiality as possible. Next slide, please. We touched on this quickly. I'm not going to dwell on it too much, but if it's suspensions, fines, anything that's not termination or reduction in rank, I will make the final determination in concurrence with the chief of police. Next slide. The executive command vote, again, if it's termination or reduction in rank, it goes before the executive commanders where they vote, and I present them all the evidence based on the facts that we've determined in internal affairs. Next slide. The Citizen Complaint Oversight Panel, I know we got a couple questions about this last time. Again, CCOP is an independent panel appointed by the County Executive's Office to help us remain impartial and make sure that these investigations are complete and thorough. They are a very diverse, intelligent group of citizens that live within the community. They give us another perspective on the cases that we review. Myself and Ms. Felix Lawson are always discussing new ways that we can include the panel in our investigations and just looking for patterns, any new ways and innovation that we can make sure that we're doing a thorough job with these administrative investigations, especially with everything that has been going on in the country. We've been in conversation trying to make sure that we're doing our due diligence with these cases. Next slide. The panel reviews all the investigations that we have. Per the general orders, they review reports of investigation for completeness and thoroughness, and then they respond back to the chief within 30 days. The department turns over all the internal affairs investigations, CERT and AIS cases to them. They have subpoena powers. If they want to issue a subpoena to have a person appear before the panel, they can issue subpoenas. They also can work concurrently with us or independently. And if I'm incorrect, Ms. Felix Lawson, please correct me. I haven't seen since I've been here in a year where they've worked concurrently. In most cases, they'll wait until the investigation is complete, review the evidence, and then respond back with their findings. But once we get a complaint within 72 hours, we send them a letter so they're aware of it. But they have the option to work independently with a concurrent investigation. Next,
yeah. And Major, did you want me to touch on that?
Yes,
the only thing I will say is that yes, and we do have the subpoena power, but effectively, because of the lack of resources, we have never used it. So that's something that we're working on. Yeah.
Thank you, Ms. Felix Lawson. And so we, as a department, do our best to ensure that if the panel does need someone to come out and talk to them, especially within the police department, we'll do our best to make sure that they're available, especially our investigators, to come speak to the panel. Next slide, please. The CCOP has two options when they submit their findings. They can concur with the findings that Internal Affairs submits, or they can non-concur with the investigation. One of the things that isn't listed here, or a couple of things that aren't listed here, is that they oftentimes make recommendations to us through policy. And one of the big things that we tried to touch on when Ms. Felix Lawson took chair and I became the major internal affairs is making sure that recommendations from the CCOP also made it to the investigators. And since we've been doing that, I think that the investigators are receptive to the criticism. I think that they like that they have a outside panel that's reviewing things that gives a different perspective, because a lot of times we get mired in police work. You can have that groupthink situation when you look at a case, and having a fresh set of eyes. Again, we try to have as many people review these as possible, and having that independent look at the cases has been refreshing for our investigators.
Major, let me hop in here. How many more slides do you have? We run over the 15-minute mark.
And we can probably stop here. We've touched on most of it. I think CCOP was the biggest thing. I know that there were some questions about the early warning system. I do want to touch on that before I'm done, but I'm sure it's going to come up in our dialogue.
Yeah, let's get to that. But then, do you also have any data? Because I remember they've been asking data about the investigations that have occurred. Do you have information on that as well?
Yes.
You have that within your.
No, it's not in the slides, but it was submitted to the panel. Or it should have been. If you guys don't have it, I'll make sure that you get it.
Yeah, because I think most of us would like to see some data on the findings that have occurred. If you've already sent it, that's fine. But I would like for you also to mention those and speak to those, because I think that's
Right.
important for not only us to have, but for the public to be able to see as well. So
And just to clarify findings, we submitted termination information, but do you want to see like the breakdown by year, sustained, non-sustained, exonerated?
Correct. I think that's important for, again, not only us to see, but folks at home to see as well, which is why I thought it would be
Yeah, definitely.
great to have on a slide. But let's go to the next one and let's spend 2 minutes on that, and then let's open it up for questions, okay? Can you hear me, sir?
Again, we talked about the findings. We can probably skip ahead. Final discipline we discussed. If we can just go one more slide ahead. Early warning system, one more. Again, we touched on this before, and our early warning system is to highlight any officers that are undergoing any stress. It's a way for us to determine if anything that an officer is experiencing is affecting their performance, especially when it comes to use of force, when it comes to complaints. It analyzes how many complaints an officer has in 30 days. If they have 2 complaints or 2 use of force or a combination of the 2, it says within the 60-day period. And that's some of the things I wanted to highlight on. We do have a new system that allows us to get it to 30 days. We are in a transition with the department, much like the rest of the county. We, up until 2016, did everything via paper, reports and everything. Chief Stawinski and Assistant Chief Velez instituted the RMS system, which allows officers to digitally enter their paperwork. As a part of that, just last year, our Internal Affairs Division has instituted where use of forces are digital. That's the first step in the process. Again, specifically with the early warning system, we'll soon be able to have those supervisory cases digital as well as departmental accidents, and it'll enable us to capture this information faster. Because of that transition from paper to digital, there was often a lag in the system, sometimes as long as 3 months. When we established last year, we've got that down to about a delay within 2 months, so we're close to that 60-day period. Again, the system allows us to do 30 days now, and we're hoping within the next couple of months, these early warning systems will be going out within 30 days, and soon it'll all be digital. There'll be no paper. So if there's an early warning violation, as soon as we see it, we can push it out to the district commanders. They can sit down with their officers and have these meetings in a more timely fashion. But with all technology, there's hiccups, and especially with this transition from paper, it kind of delays the process for the effectiveness of the system, but we're getting there. But that's for the presentation. I'll make sure that I have the data for you guys and get it put on some slides. I'm trying to think if I missed anything. I know I rushed through, but I'll take questions.
No, yeah, let's take questions now. Let's keep the slides up just in case our members want to go to one of the pages. Go back to one of the pages here. Any questions? I see Miss Judge, do you have any questions first? Let's go to you first.
No, I don't have any at this time. Thank you, Delegate.
Okay. Yeah, so let's go to Miss Yamet Gutierrez.
Hi, just a quick question. I want to make sure that I understand the use of force policy from the general orders. So a use of force report is still required even when it's not a serious use of force. Is that correct?
That's correct. And we've actually recently, and I want to say January of this year, have actually modified our use of force policy to make it more stringent. Before there actually had to be a technique used by an officer, an arm bar, a takedown, a punch, or a strike. Now, if it's just simply as me putting my hands on you as an officer, you pulling away and me pulling you back, that's actually documented as a use of force now. So we're ensuring that our supervisors, we have training in January of 2019, and the training and education division has been making sure that that's been pushed out during in-service. But we've seen good response from that, and actually an increase in use of force reviews that are documenting these situations. So.
Okay, and just a quick follow-up to that. If a person isn't charged, is a use of force still required, even if it's not a serious use of force?
Yes, that is a good question. Yes, a use of force is required whether the person is charged or not.
Okay, thank you.
Yes, thank you.
Thank you. We'll go next to Ms. Josephine.
Hi.
Morning.
Yes. Good evening, everyone.
Good evening.
I have a question about the complaint flow chart.
Uh-huh.
Please excuse me for that phone ringing in the back.
No problem.
In this flow chart, we see some Y's, some
Uh-huh.
N's, some N, and we see a Y,
Mhm.
N, and a Y.
Mhm.
What are those indicative of?
That's simply explaining that if the officer, yes, so if you're on the right-hand side and that first Y, that's yes, they accepted their discipline and it goes to final discipline. The N is no, that they didn't accept their discipline and they elected to go to a hearing board, and the same on the other side or in the middle.
Okay, and so the final one in the middle means there was a final discipline.
Yeah,
Yes, they agreed to it. No, they didn't agree to it.
It's yes, they agreed to it, or if you go to the other side, if they went no and they elected for a hearing board and the hearing board has their finding, then it goes down to final discipline. So down at the bottom is when the case is complete.
Okay.
And final discipline's enacted.
Okay, thank you.
No problem. I know it's confusing.
Yeah, I was gonna request that you just blow this up and do it again, man, because this is confusing.
You'd be surprised how many times we have to go through it. Again, it's a complex process and it's hard to explain in one.
It is. But then I will also say, just to add to Ms. Josephine's question, is that when you go to the internal affairs portion of it, you're missing with this investigation submitted to Commander. You mentioned a lot of stuff that's missing within that section there.
Right. Yeah.
Should add in some steps. But let's go to the next question here. We have Miss Judy Danza.
Uh-oh.
Hey. Hello, McQuarrie. How are you?
Good. How are you?
I'm good, thanks. Okay, so one, thank you so much for part 2 of your presentation. We really appreciate that. As you mentioned, the CCOP is a big area of concern with respect to the review process. And I think particularly in light of the discretion that they actually have. So I appreciate you touching on the added value and the benefit that they certainly do bring to the investigation process. My question is related to any additional oversight or steps to sort of investigate findings that are either unsustained or unfounded in terms of the allegations, particularly when CCOP may also not concur with the ultimate resolution or outcome. Because you mentioned that oftentimes at that level, the complaints are, maybe a citizen's word versus a law enforcement officer's report. So I just wanted to know if there is a further opportunity to sort of do a re-review of those unsustained or unfounded allegations.
Again, we're bound by that year timeframe, but if it's within that year, at any point in the review process that I mentioned, even from CCOP, if they have recommendations and there's time in the investigation, if they see something and they say, hey, another witness that needs to be interviewed, or we found a person in the call records that maybe we should talk to, we saw somebody in some text messages, we'll go back and we'll re-interview. Again, we have to get it done if we're going to sustain a charge within a year, but any recommendations we get at any point in the process, we send it back to the investigator to follow up on.
And some of the data that you did share with the task force speaks to the timelines on, some of the investigations, correct? Mm-hmm. Okay.
Yes.
All right. Thank you.
Thank you. Kenmore Middle School, of course.
Absolutely.
With the hard question.
Hey,
that's my middle school bed.
Drew Freeman all day, man.
I won't hold that against you, sir.
I would just add to that question that, it'll be good to know the CCOP's complaints, their recommendations, if they were different from what how many were different from what the police department has issued or IA has issued.
Yes, and I think Ms. Felix Lawson will touch on that, but they do issue an annual report, and with the data that's online and accessible to the public that shows the
yeah, but I think the issue what I'm seeing with a lot of the presentations from the police department is that there is a lack of data that we don't have in these presentations. And I went through a seminar this past weekend, and it was a lack of data that was in there. They even tried to skip over the data, which I didn't allow to happen. But we need the data. We want to see these numbers, man, because they all matter and they're really important. So
Yep, but we'll definitely make sure we get it to you.
let's go to our next question, Mr. Keith Lockridge.
Good evening, Major.
How you doing,
Actually,
sir?
most of my questions are data driven, and I'm going to accept that you're going to get us the data because I'm not going to sit here and just start throwing questions out. But let me ask, there are a couple of things that I just want to get a sense of. How long on average, I mean, just on average, how long does a normal investigation, a serious investigation take, one that would be sustained and one that would be not to the supervisor, but to actual IA? How long do you think one takes?
And it depends. With the criminal investigations, they can often be lengthy because it has to go through the judicial process. Criminal investigations, we seek to have our investigators complete them within 90 days. And during that process, things come up, and it may go past that depending on some instances in the case. But our goal is 90 days, and most times we meet that or surpass it. One thing that did come up that I'm going to touch on that might be in the questions is notifications to citizens, because the 90 days reminded me. We make sure that we're informing our citizens every 30 days by phone. Soon our complaint forms are going to be updated where we'll get emails. So we will make sure that we're following up through email. Traditionally, just a letter was sent at the completion of the process. So now we're making sure we're in contact as much as we can throughout the investigation. And then we're following up with a call and a letter, giving them the disposition or the findings of the investigation as well.
And how many investigators do you have in IA? I mean, so basically what I'm really trying to get is both timeline and caseload of your investigators. Because like you were mentioning that there were 800 use of forces that Renee Joy might have to look at. Is that for a year? Is that for a time period? What really is the caseload for your investigators?
We actually have 46 sworn personnel in internal affairs. But I think where the disconnect is too, is there's a difference between a use of force review that's done on the supervisory level. So it goes up through the chain and into internal affairs, and an actual internal affairs investigation. So like the serious uses of force, and I can get the numbers for exactly how many we've had. 4 years. Enough, or do you guys want more data wise? I think we've submitted this, but just to make sure if we haven't.
I think we want to go back as far as 5 to 10 years, man. Just give us as much as you can give us,
Okay.
And just to jump in here, sorry, Mr. Lockridge, but you said 400, you said you have 46 staff members. Are those, I think his question is, are those investigators? How many investigators you have?
Yeah, sworn personnel is 46. There's 16 in CERT, and how many? 16 in CERT and AIS. Yeah.
Okay, and I mean, you probably in the data this will come out, but just what I was really getting at is what the caseload is. Because if you're trying to close cases within 90 days and you have an enormous caseload, or, I mean, really, the amount of time you can put on a case is really when I get it. Will that be kind of in the data you're going to give us, or can you give us an idea of that right now?
We could give a breakdown, but approximately each investigator is carrying about, what would you say, 10 cases?
10 to 12 cases.
Yeah, 10 to 12 cases a year. And again, you touched on a point that I hope the panel hears too, is and I don't know if training and recruitment has been back, but we could use definitely more investigators. We do a great job. We've brought over great personnel that get through these cases. Again, I think I mentioned it last time, but Ms. Felix Lawson has the privilege of seeing just how much work goes into these investigations and how much data is there. Great job hitting the timelines and getting the information over. And her presentation can probably attest to, the amount of availability and flexibility that the officers have to get these cases done. But exact numbers for you and break it down per investigator, but it's on average 10 to 12 a year.
Okay.
Yeah, on that same, great. Okay, let's go to the next question. We have Miss Crystal Oriana.
Thank you. Just on the data point, because I'm not sure how detailed it would be so when we're looking at the breakdown of like what was exonerated or found non-sustained. Something that would be useful for me and I think everyone else is specifically when we're looking at use of force, for example, knowing how many of those were exonerated, right? Because based on what you said, that's when force did take place, but based upon your determination as a police department is found justified. So seeing, like, for example, if 90% of those are always, you know, exonerated, I think that helps us paint the picture of if that is something that should be done internally and how that is being reviewed by the police. So seeing it in that context is really important just for myself and I think everyone else. And then a question I had, kind of going back to the Officer Bill of Rights, when we've been having this conversation, the 2 times it's been brought up, it's really been brought up in the sense of it's important for due process and it's important for these 5 days to get a lawyer and just understanding, like, is that in that you said that you needed usually 5 days to investigate, is that common practice not for police for if it was a normal murder suspect or assault suspect, that it would be 5 days before you would interview them to investigate?
It depends on the case. Often when I was in homicide, it did take time to amass that information. Again, what's different between our investigations and the criminal investigations is that we tend to have more time. Again, there's the public safety narrative. If there's somebody that just killed somebody, we have to take them off the street. Again, oftentimes they evoke their Fifth Amendment rights. We try to get a statement from them as soon as possible because more than likely, once they are processed, they're going to obtain a lawyer. But often is a deficit to us because when we do that initial interview in homicide, oftentimes we have that one shot and we miss evidence. There's video that we could have challenged them with. There's witness testimony. So it's often like a rushed process to try to get everything that we need to begin asking the questions that we need to the person. So most times I wish we were able to arrest the person that day and then do the interview that day, but it often takes at least a couple of days before we're able to develop them as a suspect and have the probable cause to bring them in. So yes, in most cases it does.
Yeah, and I guess that difference would be, to your point, it's days to find the suspect versus the suspect's there automatically in these cases. But I digress. And then to that point though, outside of that due process and the 5 days to receive a lawyer, is there anything else that for your department standpoint is beneficial from the Officer Bill of Rights? Because that's the only point I've heard raised, and it's such a huge conversation point. So if there's anything else beneficial that you guys would like to elevate other than the 5-day delay in due process.
Yeah, those are the 2 biggest points. Again, due process allows us to make sure that when we do terminate an officer, they remain terminated. And I've even talked to the union lawyer about this, who represents most of these cases. And they're not 100% steadfast with the 5 days anyway. Like if we were to serve them with their duress, it often takes us time to amass the case anyway, like I said. So it doesn't necessarily have to be steadfast in there, in my opinion. Again, I'm no legal expert. I just investigate the cases, and in my preference, that 5-day limit isn't something that's often necessary because we're going to make sure that we have the best case to present before we interview the officer anyway.
Thank you.
Thank you for your only 2 questions, Crystal.
I'm trying to work with you, Alonzo.
Yeah, last time she hit me. Rattled off like 3 or 4.
We're going to go to Mr. Councilmember Streeter.
Good evening.
How you doing, sir?
Trying to understand if higher ranking officers follow this same process.
Yes, the process.
Oh,
I'm sorry. I think I might have cut off the end of your question.
Yeah, either complaints from lower ranking officers or the public. Do they follow the same pattern? And who?
Yep, they follow the same pattern, whether it's an internal complaint that originates within the department or external complaint. They follow the same path. One thing that I didn't mention, anonymous complaints, we get a lot of those, and we do our due diligence to try to make sure that we have the information necessary to follow each of those complaints. But even several of our internal complaints are anonymous, but we do follow the same path, and it doesn't matter rank, we're investigated no matter what form or fashion we get it.
Now, your actual relationship with the officers, you work alongside of the same officers that you may end up investigating?
Yes, I have. Not currently. I'm now assigned to internal affairs. I guess there could be a rare occurrence where an affairs investigator is being investigated. But yeah, during my 17 years on the police department, I have investigated and sustained charges against people that I've worked with. Yeah.
So the way you're structured right now, you don't have a regular interaction with rank and file officers. You mostly only come in contact with them during an investigation?
For the most part, again, there is, interaction in public space, or as I'm, going through headquarters, or if I'm in another district or something like that. Again, one of the things that we wanted to open up was the environment in internal affairs. We wanted to make it so it's personable. I want officers to feel comfortable approaching internal affairs and reporting another officer or submitting a complaint or asking questions so they can do the investigations that they need to do on a supervisory level. So we want to make sure that there is a level of authority in internal affairs, but there's also a level of approachability. So we're getting that cooperation that we need from the department. Because just like with the community, if we're walled off from the department and they don't think that we're trying to investigate these complaints impartially, that we're trying to do our due diligence with it, it affects our interaction with closing some of these cases. So we want to make sure we still have that almost community policing in the department, if that makes sense.
Thank you, and thank you, Mr. Chair.
Mm-hmm.
Thank you. Let's go to the next question. The next question is Mr. Orlando Barnes.
Yes, thank you, Major, for the information. A lot of what you talked about is kind of reactionary. You get a complaint, do an investigation. Can you talk a little bit about anything that your group does proactively, maybe to address trends you've seen, or like you say, you get he said, she said complaints, you don't have enough to sustain it. Do you have any programs to doing a little bit more to ensure the integrity of the agency?
Yeah, and you actually touch on a good point, and that's an excellent question, because one of the things that we noticed, again, myself, Captain Robinson, and Captain Watson, when we came over, is that we were reactionary. And one of the things that I sat down with then Chief Stawinski and then Assistant Chief Velez, who's now the interim chief, is trying to be more proactive. And I mentioned on the last forum is that we're looking at our data and trying to be reactionary, because as an investigator by trade before I came here, I often want to know the why. So if there is a domestic incident, why did this occur? Could we have prevented it? So some of the things that we've been trying to implement is as a part of discipline, if an officer is sustained, is making sure that they're getting counseling early on. Even if it's something as small as courtesy or off-duty violations, things of that nature, we're making sure that they're getting programs that will prevent anything serious from happening in the future. Domestic counseling, child custody seminars, remedial training, even with use of force. If there's a problem in your second year with your technique and the way that you apply force that causes you to escalate the situation, we're sending officers back to training to clean that situation up. The same thing with approaching people and making sure that they're de-escalating situations and not escalating them verbally. The manner in which you approach somebody we see is very important. And when we came over, something that seems minor, like a courtesy violation, which can start at a written reprimand, is very important, because how you interact with the community is how they're going to interact with you. So that you only get one chance to make a first impression. If you come to that scene and your first impression to that people is adversarial, they're going to be adversarial back. So we want to make sure that we're respecting people and we're treating people how we want to be treated, or how our family members want to be treated. So that's one of the things that we're working on. We're trying to expand and use the data that we're collecting. Again, we have IA Pro and Blue Team that's allowing us to digitally compile this information. again, we were doing it, going through hand reports manually up until a year ago, and for the department 4 years ago. But we're taking advantage of some of the technical strides that we have to calculate and amass this data quickly so we can remedy some of these situations. But thank you for that. That was a good question.
Yeah, if you can send us that in writing about these proactive measures, I think that'd be
definitely.
It'd be good to know, because it does, a lot of this does seem reactionary, I would say. Let's go to Ms. Felix Lawson.
Hi, thank you, Delegate. The only thing I wanted to mention, and it was already mentioned before by Major, that the CCOP does publish an annual report, and the 2019 annual report was published about a month ago. And it does talk about some of the recurring issues and trends that the CCOP finds in its review of the cases, and will give also the public a summary of the cases that the CCOP reviewed. And so I just wanted to make sure that the public was aware of that and can go through. It's about a 57-page report, but we tried to provide a lot of data in a narrative form, so it can be easier to kind of get a snapshot of some of the major issues and recurring trends that the CCOP has found. So I just wanted to mention that to everyone.
No, thank you for that. And I think we should probably have maybe you or someone at CCOP probably conduct a presentation for us as well and provide that information.
Sure.
It seems like in this presentation we're missing some key points and some key data that we can probably help or enhance in our recommendations. So thank you, Ms. Felix Lawson. Appreciate that. Let's go to our next question, Mr. Glenn Ivey.
Thank you, Major. Appreciate you coming in.
How you doing, sir?
I'm doing well. How are you?
Good. Good to see you.
My pleasure. So I'm trying to figure out exactly how what governs the process. So I take it from what you said and my recollection from when I was in office, if Chauvin had killed George Floyd in Prince George's County, he could not have been terminated immediately. Unless, I suppose that you could, but he would have been potentially reinstated. Is there a scenario where, there is an express where, what you see is just so egregious that you can fire somebody? And does that ever get used in use of force scenarios?
That's another good question. One of the things that we saw, and this was prior to George Floyd, was the unfortunate murder of Mr. William Green. And in that situation, we saw that use of force was so egregious that we worked in conjunction with the state's attorney's office and charged Officer Michael Owen the very next day. So he was immediately charged through probable cause, arrested on view, and placed into custody within the day of that incident. So that is something that's changed. That definitely was a use of force incident. So in those situations, we are trying to evolve, we're trying to adapt, and panels like this allow us to constantly look at our policies and processes. But that was one incident, and fairly recent, even before some of the national reform that transpired throughout the nation took place, that we were at the forefront of trying to get ahead of something like that. So.
And 1 second question, I promise not to go too long. To what extent is that flow chart, which is looks like a puzzle of some kind, really? But is that driven by LEOBR? Is it driven by the collective bargaining agreement? Is it internal regulation, some kind of mix of all of the above? Yeah. And to what extent are there ways to sort of shorten it up and cut to the chase a little bit?
And man, you guys are good because you're hitting on all the things that we're doing. We actually recently had a conversation with myself, the interim chief Velez, and the Ms. Felix Lawson with the CCOP. And one of the things that we're doing in our orders is to actually denote where we're getting our training, where we're getting policies and procedures. So instead of just citing county code, we're going to do things like the IACP recommendations. We're going to cite, the 5 pillars. We're gonna cite things that we see within the national trends, but it's a combination of everything. It's a combination of county law, state law. It's a combination of LEOBR, county code, personnel law that all kind of mashes up into the process as well as criminal proceedings. But there's so much that goes into this, and I don't know if there's a way to shorten it. Again, if the panel has a recommendation, but we want to make sure that it's thorough, and we're often adding additional facets every time that we have these discussions. So I think it was 15, 20 years ago, maybe even longer, where CCOP came to existence. There was a point when there was no CCOP, and that wasn't in the process, or there was a point when there was no executive review for the commanders to look at it, or there was no internal affairs oversight for a supervisory investigation. So each of these are additional checks and balances that we've added to make the process more thorough and impartial. But the short answer to your question is I don't know how to shorten it, but I'm always open to suggestions and ideas.
All right, thank you.
Yeah.
Yeah. Last question before I ask a few questions, Ms. Sonia Pruitt.
Thank you. Hi, everybody. Thank you, Major.
Hey, Ms. Pruitt.
I have a statement and 2 questions. The statement being, when we're talking about caseloads and investigations, there seems to be a real emphasis on use of force, which is to some extent appropriate, but I'm hoping that the panel understands that there could be other egregious behavior that's outside the scope of use of force, such as harassment and other types of behavior. That's my statement. My first question is, what is the demographic makeup of the investigators in internal affairs?
I'll get you a breakdown so you guys can see it, but I'll break it down. We have 20 Black males, 5 Hispanic males. I'm sorry, 5 Hispanics total, 10 whites total. There are 8 females, Black females, 2 Hispanic females, and 1 white female. But I'll get the numbers. I know I'm reading them off, but I apologize. I thought that when we submitted everything that it got over to you guys, but maybe not, and we'll streamline that to make sure you have everything that you need.
If I missed it, I apologize. My second question is, if you have an internal, I heard you say that you basically handle internal complaints, especially if they're anonymously the same way. Mm-hmm. So is there a special process for any type of internal complaint, such as harassment or discrimination? Like how, and then the second part of that question is, how does EEO, how are they worked into that process?
There isn't a separate process. Again, we'll assess all the evidence that's there. If it's anonymous, oftentimes there's difficulty investigating them depending on how thorough the complaint is. We try to get as much information on the complaint forms, and especially when we follow up with our complainants to get more details as to what happened. But we take all the information that we have in that anonymous complaint and investigate it as thoroughly as we can. We've actually had anonymous complainants that do come in and participate, but wish to remain anonymous. So if there is contact information of any form or fashion, we try to make sure that we extend that to them. EEOC is a separate entity. If it's within the department and it's an internal harassment complaint, what happens is it still comes to internal affairs oftentimes, or it can go directly to EEOC. If it comes to internal affairs, we will send it to EEOC, allow them to review it. If they determine that it's a EEOC complaint, it'll go through their process. If they determine that it's a harassment that internal affairs should investigate, then we'll keep it and we'll conduct it like we would our normal investigations.
All right, thank you, Ms. Pruitt. Just a couple quick questions for you from myself, then I'll go to Mr. Ruddy. Actually, Mr. Ruddy, why don't you go ahead and ask your questions first?
Thank you, Major. Thank you for being here. One quick question. Good. One quick question. At some point in time, the department required every investigator to have a specific rank to be an investigator in internal affairs.
Mhm.
That policy was changed, and now lower rank officers are able to be investigators. Has there been any difference since they started allowing ranks lower than sergeant to investigate internal affairs matters?
Again, this would just be opinion, and I've been here a year, but in my experience, no. One example is we brought over, and what Mr. Ruddy is talking about is to come over to internal affairs, you used to have to be a sergeant or above to be an investigator. So primarily investigators were sergeants. And I don't know when or it was before I got here or why they did that transition. My assumption is it was manpower needs to get as many investigators over. But a perfect example is we've brought over corporals that I've worked with in homicide that are excellent investigators. And we have seen actually an increase, in my opinion, in the quality of investigation because we've brought over, again, outside experience and insight. But again, I've been here for a year and I can only comment on the cases that I've seen, but I don't think that there's been any impact in allowing corporals to investigate the cases, but it doesn't go lower than corporal. That's our cutoff.
Thanks, Major.
No problem.
Just to react to that question, did you say that it used to be sergeants only coming to invest into IA?
Correct.
Now you have the lower ranks; they also are able to come into the internal affairs. Was that the policy that changed?
Yes, corporals and above now. It used to be sergeant and above, but now we have investigators that are corporals.
And why is it a necessity that they must be either a corporal or a sergeant or even a officer in general, that they have to be internal affairs? Why is that necessary?
And initially, I believe that the mindset was that something that's administrative investigation should have somebody that's at a supervisory level that has experience with the supervisory process. I don't believe that that's the case. And again, in my experience, especially when we're able to pull guys and girls from homicide, we're able to pull them from CID, which investigates all our serious cases. I've seen an increase in amount, and also it affords us more opportunity for the rank and file to come over, if especially if you want to be a part in the administrative investigation.
The second part of my question was the most important part of that question, but thank you for your answer, which is why does someone has to be a sworn officer in order to be in internal affairs?
Hey, Delegate Washington, this is Joe Ruddy. Can I just add a little bit of information? The LEOBR requires anybody to investigate to be a sworn officer.
Got it. Fair enough. Okay.
Thank you, Joe.
Great. Okay. My next question was going back to the IAD review process. You have one now in your circle of your diagram. As the lieutenant, major, corporal, and everybody else that's within the review process, are those folks within the agency, within the internal affairs, or are they
all within internal affairs? For the supervisory part, they're within that chain of command, and then it comes to internal affairs. For an internal affairs investigation, all the review that starts with the peer review and goes to the chain of command within internal affairs. Yeah.
Got it. Hey, everybody, I would just say this. I see a few more questions being popped up here that we're over the time limit for trying to get to our next presenter. But I'm gonna ask Ms. Tara Jackson to ask another question, and then I'm gonna make a comment. Then we're gonna close to go to the next presenter, if that's all right. Ms. Jackson.
Thank you. Hi, Major. This is, and maybe it's not you that can answer this question, but does the LEOBR also require that the board be all sworn officers? So the administrative hearing board be only officers as opposed to civilian, as opposed to allowing a civilian to sit on the administrative hearing board?
I'll check. I believe so. But there was an addendum recently, and I don't know if Joe has that answer, but I'll look it up and definitely get back to you on that one.
All right, thank you.
And as we close, I'll just say this. I want to say, Major, thank you for your time here with us. Do you have any closing remarks for us at all?
No, I just, I thank you guys for allowing us to have the opportunity. I understand how important police reform is. And again, we want to do our best to make sure that we're ensuring that these cases are done thoroughly and we're giving the community the type of police service that they deserve. With that said, I apologize, Ms. Brave Boy and Ms. Joy, for stepping into your time.
Yeah, look, I want to thank you as well, again, on behalf of the task force for coming here again and presenting to us. I'll just say this, and if you can ask the chief with anyone else that comes to speak before us, if they can have the data in front of us to be able to show, because again, you're not showing the data just to us, you're showing the data to the community. And also, it does seem like there are some changes that are being made within the police department. You mentioned several of them that you're considering right now. I think it'd be good to have those as well, things that you are changing, so that we are working together and not separately. Because if you're making changes that are happening along the same times that we're making our recommendations, maybe we can work together to make that a priority as well, and sent to the county executive office. So I would just urge that the police department, when they conduct their presentations to us, is have that really important information to us so that we get a holistic picture of what's happening, and so that we can make a clear and concise recommendations to the county executive.
Yep, I agree. Thank you.
Thank you very much.
Thank you very much, sir.
Thank you. Thank you, everyone. Thank you, everyone, for your great questions. Next, we're going to go to Ms. Renee Joy from the State's Attorney's Office to conduct her presentation. And we want to thank you so much for being here with us. And so, Mr. Bender, if you can place her presentation up, and we'll go from there.
And Delegate Washington, this is Aisha Braveboy.
Oh, wow. Okay. I didn't see you on here. Excuse me.
And I apologize. I'm actually going back and forth between two Zoom meetings. I know you know what that's like. So I'm going to be here just for a very short time. Then I got to jump off, go on to my other one, and then I hope to make it back. So I actually was going to present the first two slides and introduce, of course, Ms. Joy.
Oh, awesome. Okay, well, Mr. Bender, can we put the slides up quickly for Ms. Braveboy before she has to hop off? Thank you.
Thank you so much. I think you can just go right into the next slide.
Okay, I think he's gonna try to make it wide.
Oh, okay, sorry.
It's all good. Mr. Bender, I think it's cut off halfway for us at least. Is that correct for everybody else? Is that the same?
It's yeah, there it is.
There we go. You got it.
Okay, we got it.
Yep.
Okay, great. So thank you so much for this opportunity to introduce our chief of our public integrity unit, and also introduce our new unit that was created under my administration. The function of public integrity has always, I think, at least under the Alsobrooks administration, and I assume under prior administrations, has always been a function of the state's attorney's office. However, best practices, and really all of this is developing over the last, maybe 5 or 7 years or so. Best practices suggest that the public integrity unit should be a separate and independent unit, so that those prosecutors that are handling cases of use of force, police misconduct, aren't also prosecuting cases involving some of these officers. So there's a separation in those types of functions. And so we have a standalone public integrity unit. So in addition to our police cases, we also investigate allegations of misconduct by elected officials, as well as government officials. And so we do investigate those cases as well, and we prosecute when appropriate there. But for the purposes of this presentation, we'll focus more on the unit's involvement in police investigations, as well as prosecution of police misconduct and use of force cases. And so we unfortunately have had several officers, both Prince George's County police officers as well as municipal officers who have engaged in misconduct in our community or just committed just out and out the most horrific crimes you can imagine. And so we have prosecuted 2 of those cases successfully. One was an assault case, the other was a sexual assault case. And we have other cases that will be prosecuted either later this year or early next year. So the unit is busy. One of the things that, and I know that Ms. Joy will go into this, is that as we talk about reform and change and transparency, that also puts a lot of pressure on the state's attorney's office to produce discovery for our wonderful public defenders, who I know are on the line, as well as defense attorneys. And also we want to protect the process. So we want to make sure that we are being transparent, getting as much information as we can, reviewing that information, and making the appropriate disclosures. So all of that takes time and resources. In addition to that, I know that the police department is deploying body cameras throughout the Bureau of Patrol, which we think is the right move. So we definitely applaud the county executive and the council for making that move. But again, that puts pressure on our office to review more footage, which we are happy to do. We just, of course, want to make sure that we have the resources to do it. So we are really excited about this new phase, I think, in the criminal justice reform process, because we do believe, because it is including community more, we do believe that it'll yield really great results, but it also revealed to us a lot of the needs in the system to be able to be transparent and reformative. And so we're hopeful that during Renee's presentation, you'll hear about some of the challenges and also some of the opportunities we have here in Prince George's County. Next slide.
No, that's from
And that brings me to Renee Joy. She's the chief of the Public Integrity Unit for the Office of the State's Attorney for Prince George's County. As I mentioned before, this is a new unit that was created to investigate and prosecute crimes of government waste, fraud, and abuse. She also is tasked with investigating police misconduct and reviewing use of force cases. Ms. Joy began her career about 15 years ago with the Prince George's County State's Attorney's Office. So she has really risen through the ranks. So we consider her homegrown and certainly capable and ready to lead. So I will now turn the mic over to Ms. Joy.
Thank you, Ms. Braveboy. And, I want to take the time to thank everyone for having me here today. I really look forward to speaking with you. And I just wanted to talk to you a little bit about what it is that our office does and what the Public Integrity Unit does when it comes to reviewing and prosecuting police cases. We do have a part of the unit that does end up doing, more financial cases involving government officials and employees, but being with this work group, I wanted to concentrate particularly on what we do when it comes to police. If I could get the next slide, I'd appreciate it. Ooh, okay. And I appreciate Major McCrary giving you a really in-depth view of what it is that Internal Affairs does. And, we do appreciate and we do have a really good working relationship with Internal Affairs. And they do end up, especially we work obviously the most with the Special Investigative Response Team, or CERT. And the reason for that is because they are handling most of the they're handling the majority of the criminal cases. So, when we, fortunately we have a system where I do get notified whenever CERT responds on scene about something, they're really, really good at calling me and giving me the heads up of what has been coming down the pike. And, you know, sometimes we do have the opportunity as a unit to go out there and respond to the scene to see exactly, you know, what's going on. And that's also been really, really helpful. And it's, you know, we really began getting involved with CERT and IA at the very beginning stages of the investigation. So we're notified within minutes of something happening. And it really helps because then we are able to, you know, kind of help them and guide them and make sure everything is getting subpoenaed. The witnesses that we want being investigated the witnesses that we want being interviewed are being interviewed. And it's just been helpful to start that process a lot earlier on than we used to. So I want to thank, you know, Major McCreary for his aid and his help and with getting that process started. So we do get involved, you know, at an early stage of the investigation most of the time. And what we end up doing, like I indicated, is we coordinate the investigation, and then we kind of take it upon ourselves to do an independent investigation. So there's several different ways that my understanding is that a use of force investigation comes about. And you know, you have use of force reports, you have supervisory reviews of that, as Major McCreary says, and a lot of times those things are not going to be reviewed by our office, especially unless it involves some type of criminal element. So that is one way something comes to our office. If I could get the next slide, that would be great. Other things that come to our office, as Major McCreary indicated, we do investigations into any time an officer's weapon is deployed, whether or not it's fatal or if it's a contact shooting or a non-contact shooting. The only shootings that we will not review are like when there's a shooting in order to like euthanize an animal that's on a road, or an accidental discharge or something of that nature. But what we do, we get our cases from, you know, CERT, we get our cases from the commissioner's office. There are some times where citizens will go to the district court commissioner and file charges against an officer. At that particular time, we're not capable of, the commissioner is not statutorily able to swear out charges. The rules indicate that police officers, firefighters, and educators who are complained against at the commissioner's office, charges or warrant will not issue. It needs to come to the state's attorney's office for review. So we get cases that way. And there's sometimes that we do end up referring those cases back to CERT as well to look at. So what do? We coordinate the investigation and we do our own independent review. A lot of times what that entails for our office is we work with not only CERT, and we do work with the Prince George's County Training Academy. Those trainers are really, really useful, and they're a wealth of information. But what we have done recently is we have taken the time to try to contract out force experts in order to do an independent review of a particular case. I know we've contracted with Dr. Tyrone Powers. We've contracted with Mr. Dickerson, who was a former Montgomery County police trainer for 13 years. And we asked them to also conduct an independent review on the case. We're in the process, we're actually trying at this particular juncture, it's not been finalized, but to get a more consistent contract with Dr. Powers and Mr. Dickerson so that we can use them a little bit more easily. But that's kind of in this finalizing stage, so we don't have to, each time we need to use them to review a case, request funds from the county in order to use that. So Some of the things that we can do when we get a case and when our review process is completed is we can grand jury the case. We, utilize our grand jury a lot. I know the grand jury goes to the training academy for the Prince George's County Police Department Training Academy to do they call it a judgmental shooting course, where they do a half a day training with the police department. And we use them a lot in order to present our cases and to kind of get a citizen's eye on the case. The grand jury, for those that don't know, are made up of a series of 23 citizens that get to, request information, ask questions, and and make decisions on cases based on, the facts. They hear testimony a lot of times from witnesses with regards to this case, with regards to our cases. They get to review all the video, and we allow them to speak. We present to them use of force experts so that they can ask any questions about police training and such. And at that point, then our office sometimes will make charging decisions on our own. So, once everything is, the investigation is complete, we have a committee that we meet with, and I or whoever's handling the case will make charging recommendations to that committee. We'll decide together whether or not we're going to present the case to the grand jury, or whether or not we're going to decline to prosecute a case, or whether or not we're going to pursue charges outside of the grand jury. At that point, we make the decision. I could take the next slide. While we're talking about the way that charging decisions are made, I just wanted to take the opportunity to, just go over some of the case law, because I will say that, the case law that dictates the level of force that police are able to use in order to meet a criminal standard is set by, the Supreme Court, and it's also set by Maryland law. And the leading case that everyone cites to when we are prosecuting these cases is Graham v. Connor. And the holding on that is that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. Calculus must embody allowance for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving, but about the amount of force that is necessary in a particular situation. So, not to get too technical on you guys, but basically what Graham v. Connor holds, it was a federal Supreme Court case. And the holding in Graham v. Connor basically says that when an officer uses force, they are in essence seizing an individual. So they are, under the Fourth Amendment. So, the Fourth Amendment protects against all unwarranted searches and seizures by government. So because it's a Fourth Amendment analysis, you have to look at it from an objectively reasonable officer. So, the good intentions of a police officer are irrelevant in that analysis, and so are the bad intentions of police. It's irrelevant because it has to be judged from what an objectively reasonable officer will do at that particular time. So that's why it's important that we have relationships with experts and former police so that we have a feeling of, what an officer, a reasonable officer would do in a particular situation. They have the experience, they have the training, and they are able to answer those questions, because it's not necessarily what you or I or, any citizen is going to do in a certain situation. It's always going to be from the perspective of an objectively reasonable officer. And if I could get the next slide, Maryland, the state of Maryland adopted the Graham v. Connor standard in Wilson v. State. And basically it takes that objectively reasonable officer that's in the civil Graham v. Connor case and applies that standard in Maryland to a criminal matter. So basically the holding in Wilson v. State is a police officer from the perspective of a reasonable police officer may use only that amount of force reasonably necessary under the circumstances to discharge his duties. So, that's a really, and as many of you guys know, when we prosecute our cases, we have the highest burden. We have to prove our cases beyond a reasonable doubt. So when you take into consideration what that case law says and what the standard is, they're actually really, really tough cases. So something that looks cut and dry to the community as an unreasonable use of force, when you do that analysis that Graham v. Connor and Wilson v. State warrant, they make cases that appear sometimes very, very tough or very cut and dry to the community, or what you're watching on social media or on CNN or wherever you watch your news. And it really makes them a lot more challenging and more complex. Sometimes, we have a case that will charge an officer with like second-degree assault and misconduct in office. Well, your average citizen, when they go and they do a second-degree assault trial, it's going to be a half-a-day trial. But, when you charge an officer, those cases end up being a week long. And they're, and generally speaking, in the state of Maryland, a police officer generally will take a bench trial. He'll elect to waive his right to a jury, which he is entitled to do. Every citizen is generally allowed to choose between having a bench trial or be judged by a trial by jury. And if they waive the jury trial, then the finder of fact then becomes the court. And because of that, generally the bench is a body that's able to take emotion out of it. And I feel that because use of force cases are very, very legal and technical in nature, the judge, I think that the police officer trusts the judge to make the decisions for them because of the legal arguments that surround force. Because second-degree assault, it includes it requires an unwanted touching or offensive touching that's not otherwise legally justified. So, in these cases, everyone agrees that there was an assault, but the question then becomes, was it otherwise legally justified? So I just wanted to point that out. A lot of times I hear, prosecutors are criticized or bench or jurors are criticized because, we can either get someone charged, but we can't get that conviction, or, we opt not to charge because it doesn't reach that criminal standard that you see that the case law demands. I'll take the next slide. So the other thing I wanted to speak with you about with regards to officer disclosures. Now, this has become, and it's always been quite an issue with regards to discovery. So, the Brady Doctrine requires that we provide impeachment information only where there's a reasonable probability that evidence will affect the result of the trial. However, and that's while that is a governing case in the case law, the Maryland rules of discovery, which is Maryland Rule 4263, requires that the state turn over any evidence that tends to impeach a state witness. And that's in every case, and we are required to turn that over regardless if the defendant requests that information. And, I wanted to talk about that a little bit today because I wanted to, to talk about some of the limitations that we have in regards to this request or this obligation that the state has. So we have been trying, to make sure that we meet our Brady obligations and our obligations under Maryland Rule 4263. And what that does is there's further case law, Robinson v. State, which pretty much says that the state's attorney's office is in constructive possession of the IAD files of an agency that will regularly report to our office, right? So the court, the court puts us in possession and holds us responsible for all of the information in all of the internal affairs files, not only of Prince George's County Police Department, but all of the different municipalities within Prince George's County, the Sheriff's Department, the jail, all of those agencies that regularly have cases with us. We're responsible for what's in the personnel file. If I could get the next slide, that would be great. The problem.
Mr. Joy, can I
Sure.
real quick? We're gonna have to hard stop at around 6:45 or so.
Okay.
6:47, just to give people opportunity to ask questions, because
Okay.
we're getting close to the 7 o'clock mark. But if everybody's okay with it, if you can place it in the chat that you're okay, we'll just keep going.
Okay. Yeah, I know Major McQuarrie took up way too much time.
Way too much time, man.
I was waiting for him to stop.
Definitely blame. Thank you.
That's okay. That's okay.
Sorry.
But, our problem comes because of, the state is in an odd pickle when it comes to these personnel files because, we're held responsible into being in constructive possession of these personnel files. However, because Maryland rules also require that these files are privileged and confidential, we're not given the access that we have to ensure that that we are indeed in possession of everything that we need to be in possession of. And like I said, this isn't just a Prince George's County Police problem. It's just a law enforcement and not unfortunately, but fortunately, there are a lot of municipalities within the Prince George's County and the Sheriff's Department and et cetera that, have these personnel records that we are in essence responsible for. However, we have very limited access to those files to ensure that we're doing the right thing. And, I do want to take the time to thank, the Prince George's County Police Department, and there are other municipalities that are starting to work with us to make sure that we're getting the information that's in these files, but still our access to these things are very, very limited. We have requested more access to these materials, but, being the laws the way that they are, and the requirements in order to gain this access, we do understand that we're pretty much in a bind and are getting the files that we graciously are given to us. But I have been able to work with Prince George's County and also other municipalities to get more access to these files, but the state's attorney's office as a whole is not satisfied with the access that we have. So I just wanted to, talk a little bit about the personnel file issue, because I think it's something that's extremely important. We want to make sure that not only that we are meeting our discovery obligations, but that we are protecting the integrity of our cases, because what we don't want to have happen is us, get to the point where we have a conviction and then something comes out later about a particular officer that we didn't know about. And then, all of a sudden you have a homicide trial or an armed robbery or carjacking trial coming back to the trial court because we didn't disclose something. And not only that, but, these violations, our prosecutors are held responsible for. So, we want to make sure, we have a really big interest in making sure that we know what's in those files when we are moving forward on a case. So, I wanted to talk about that today because I think that's a pretty big issue that needs to be looked at. I also think that, being that we have all of these IAD files that we kind of have to go through, and with not only with Prince George's County, but also with all the other municipalities, I just want to piggyback off of what the major said as far as our resources. Our resources in our office, can become, we need more. And especially with the body cameras coming in, a review of those issues as well. The state's attorney's office really does need more resources. I'll just say, I'll say that we don't review 800 force cases a year, thank God. But we do have quite a few, and that's coupled with the other cases that the unit does have. So, I just wanted to kind of give you guys a brief overview of some of the limitations that we have, not only with the case law when it comes to prosecuting these unique defendants, but also with regards to our discovery obligations. I know that, there are some different entities and city, like the Baltimore City has an entirely different process for review. They were able to enter into an agreement with the Solicitor General in the city that allows, a lot more access to the personnel files to ensure that discovery is being, like the correct discovery is being provided. So I will, that's just kind of an example. We would love to have that type of access, but we understand that the law kind of restricts that. So with that said, I do want to, give you guys the opportunity to ask me any questions about those two issues. I'd be more than happy to answer.
Yeah, thank you for that. Let's hop in here real quick and see if anyone has any questions. I saw Miss Pruitt. So you have a pretty lengthy comment in here. So you want to ask a question or say your comment here at all?
No, I just wanted to make a comment so that all of the panel members could see. I don't need to ask a question.
Okay, got it. Okay. Any questions at this moment, at this time? Yes, Crystal, Miss Oriana.
Thank you. And thank you for your presentation. I found it really informative. And just a few questions for clarity. So you talked about like the decision to either go to a grand jury or move forward. What would be the deciding factor for you decide to move forward with a charge without going to a grand jury or not?
When I say, and let me clarify, because I do appreciate that, but there are, for example, different ways that a case can be presented to a grand jury. There can be a case where there's several witnesses that are presented, force experts that are presented, because we really want to take the temperature of the citizens of the county and get their input on a particular case. It might be complex, or it might involve someone that was killed. So, generally speaking, with these shootings, we want to put them in front of the grand jury so that, we can take the temperature of the community. We don't want to unilaterally make these decisions ourselves. But another way that a case can come from a grand jury is when we just kind of, present the case and they vote on an indictment without the benefit of the witnesses and things of that nature. So when I say, we make that decision to bring charges, it does technically go in front of the grand jury, but in a less comprehensive manner.
Thank you, that's helpful. And when you talked about the reasonable standards from an officer's perspective, and you cited Supreme Court case, but then also that was adopted by state legislation. So any type of amendment, just for my own clarity, can be done on the state level around that?
So it's not legislation that is governing, which puts that limitation on us. It's actual case law. So it's cases that went up to the Court of Appeals or the Court of Special Appeals and was decided by a panel of judges who then wrote the opinion then that binds us. So the decisions were made off of particular cases that the appellate court heard. I'm sorry. Let me take a drink of water. But yeah, it's based off of cases that were reviewed by the appellate courts when they got a conviction in state court.
Good.
And one more question. About, you mentioned the issue with access to in the police files. And I was just wondering if you had like a solution that you're seeing that works in other jurisdictions, or when it comes to access that you'd recommend to us as a work group?
Legislation. Yeah, I think the rules are very strict. Look at the Maryland rules along with the LEOBR. I don't see, any other way around that unless, and I know that in Baltimore City, they had an agreement involving the Solicitor General and the courts and the state's attorney's office. So, there was an agreement there. That's how I think they were able to get around it. Unfortunately, I wasn't, part of that process. But, that's what I think the only way to really do anything is legislation.
Thank you.
Thank you. Judge Lemassney.
Ms. Joy, I enjoyed your presentation. That was very good. How are you?
I'm well.
But you're basically conceding that information about an officer's prior disciplinary history would be discoverable?
If there's information in that file that goes to the veracity of that officer, I think that not all disciplinary proceedings are going to be discoverable at all. It's just the ones where there's an allegation of or a sustained finding of theft or misrepresentation of facts, because it has to go to the officer's credibility. So I don't, if there's a disciplinary action that stems from, a language violation, that's not discoverable. But if there is a violation or a sustained allegation that comes from or a sustained charge of misrepresentation of fact or false statement, then yes, absolutely, it's that information is discoverable.
What about prior use of excessive force?
I really think it's a case-by-case basis, Judge, because of the fact that I think in a case involving an armed robbery or, I think they could be discoverable. I think there's an argument for them being discoverable in a case that there's an allegation of resisting arrest when, for example, the defendant was injured during that arrest. I think that there is a potential discovery issue depending on whether or not the force was sustained or unsustained. I recognize that, when the internal affairs keeps their records, if there's a use of force report that's been investigated, that counts as a, internal affairs investigation. And so it could, and use of force reports are required whenever an officer goes hands-on with someone who is actively resisting or actively aggressive. So, I really just think that force reports or the use of force that an officer uses or excessive force allegations would just really depend on the case at hand.
Thank you very much.
I'm going to ask our attorney, Ms. Sadia Noah Hope, to chime in here. So you raised your hand real quick. So let me.
Yeah, I did have a question. Thank you. And this honestly is just a follow-up to what Ms. Joy just said. I know there was a question regarding whether or not, specifically Judge Lemassney also just asked whether or not they were discoverable. However, from what we were looking at, the state's attorney's office under the Prince George's County Code, and that's section 16-216, I believe, and the general provisions of the Maryland code, which is 4-311, the state's attorney's office has not generally been granted authorization to access police officer personnel files. They are still considered classified personnel records and they're confidential. So in terms of, like Ms. Joy did say, of course, legislation could possibly change that. However, the state's attorney's office also has the option to issue subpoenas to get that information. But as of right now, as it stands under the law, even though, like you said, they could be discoverable according to the county code, they're confidential and they are protected.
So I guess my follow-up to that is that, because Ms. Joy mentioned earlier that it will take Maryland law, it seemed like, to make some changes. So right now, Ms. Hope, you're saying that it can be changed at the county level as well.
Well, Maryland, I'm just saying that under the county code and under Maryland law, it is considered confidential. So I guess the legislation would have to be changed on both levels.
And I just, thank you, Sadia, for saying that. But, the problem with the subpoena is that, in order for this, we cannot file blanket subpoenas for personnel records because of the case law. So, you know, if we have a case and there's officers, the state is not able to just file blanket subpoenas for all of the officers, because there's also case law that indicates that the party that moves for a subpoena of a personnel file has to make a showing and that there is discoverable information within that file. It cannot be something that is a fishing expedition, according to Copley and Fields. So, you know, we can't just say, oh, there might be discoverable information in these files, let's issue blanket subpoenas. Because then when the county attorney does a motion to quash the subpoenas and comes to court, it's on the state's attorney's office to meet a certain burden that has been established by case law. And even then, that doesn't give us the files. It turns it over to the court to do an in-camera review of all of the materials, and for the court then to make a decision whether or not anything in those files are discoverable.
And how long does that process take?
It just requires, like, if we do a motion for subpoena, we can, you know, send it over to the county, and then the court has to set in a hearing in order to, well, what will generally happen is the county attorney, per Maryland rules, because they must deny inspection of these files. So they'll do a motion to quash, and then the court will hear that motion at the next court date and make a decision as to whether or not the state had made its burden in order to generate an in-camera review. But if we don't have any idea what's in these files, there's no way that we are able to generate that burden in order to meet that burden in order to generate an in-camera review.
Thank you. Ms. Josephine Morning.
Good evening. Thank you so much, Ms. Joy, for your presentation.
Thank you.
I have two questions. The case law that you actually cited, Graham versus Connor and Wilson versus State, how old are those cases?
So Graham versus Connor is a 1989 case, and Wilson was in the early 90s. And 93.
Oh, 93.
Okay. I think, don't quote me. I know it's early 90s.
Okay.
But Graham was 1989 and shortly after.
So we don't have any current case law that that has come out with this, because the climate has changed in our country, where we're having a lot of police cases. Mm-hmm. So there's nothing that is actually more recent than those two case laws that you cited to us.
There are more recent cases that have been going up to the appellate courts, you know, over the years, but they're all analyzed in accordance with Graham v. Connor. So, you know, that's the precedent. So all of the cases that go up to the appellate court have to be analyzed under the standards of Graham v. Connor and Wilson v. State. So that's why you're getting certain decisions from the appellate court, is because they're following the laws that were, the precedent that was established in Graham v. Connor and Wilson v. State. And it's very tough. And I just want to say, like, it's very tough to challenge those laws, because, you know, if the police officer is acquitted, right, because the trial court is analyzing the case under Graham v. Connor. If the police officer is acquitted, you know, that's done. There's no more criminal case. You know, there's double jeopardy attaches and the case is over, it's done with. The only way that we can get cases up to the appellate court is if we win them, right?
Right.
Kind of a really, it's a troublesome, you know, it's kind of like okay, we win them because they're egregious enough to meet the standard of Graham v. Connor, but we can't get the more borderline ones up there because of Graham v. Connor.
Okay, because it seems to me like the police officers, they are held to they have more protection, I would say, greater protection than the citizens. Because you're saying you cannot get information on them. But if I committed a crime, you would be able to get information on me. So why is the police officer, he's protected and I'm not protected.
Well, I mean, yeah.
Okay.
You know, and there's, I mean, I think there's, you know, you have to like, you know, these are their, you know, their employment requires them to go out and, you know, and run into situations that we generally, as the general public, are going to run away from. And they are often, a lot of times, you know, faced with situations where they can't stop and think. They have to rely on their training to move forward. So they are given a bit of a bit more deference when you're when they're going into a use of force situation, because we have to keep that in mind. They are going to things that everyone is running away from, you know, and I think that the law like contemplates that when it when people legislate certain ways or rule on certain cases certain ways. So that's a consideration, whether you agree with it or you don't agree with it. I just think that's what it is.
Let me ask everybody to do this. Let's take a step back from your computers, because I know everybody has a question or a comment. And I'm gonna get to everyone as soon as I possibly can. Miss Morning, I know you had a follow-up, so let me give you the opportunity to ask you a follow-up real quick, okay?
Is that a part of LEOBOR?
Is what a part of LEOBOR?
Protection these police officers have that I don't have.
LEOBR does create rights for strictly law enforcement, and it's coded in the public safety article of the Maryland Code.
Co-Chair Lamazny.
Yeah, I just wanted to say the issue with the Supreme Court case, the age is not relevant. That remains the law in the United States until the Supreme Court changes it. So, and every case has to follow that. So until the Supreme Court revisits that issue, that will remain the law.
Yeah, that's right.
And because she's the former Office of Law Director, Ms. Tara Jackson.
I'm sorry. I also just wanted to clear up something for Ms. Morning, and that is we're talking about, I think what Ms. Joy is talking about is access to employment records as opposed to criminal records. So personnel records are protected. And so that's I think, Ms. Joy, that's what the state's attorney's office is asking for access to, is the personnel records. And I suggest also, just so that we can have a fuller discussion around this issue, that we invite the Office of Law to get their perspective on the issue.
That's a good idea.
To make that clear,
Yeah.
not protecting criminal records, it is the employment records of the officers, the personnel records.
Yeah, I think that's a great suggestion, but I also think that we should have the state attorney's office around while we're having that conversation too.
Absolutely.
Let's make sure.
Because they may have different perspectives.
Correct.
Yeah. And thank you, Ms. Jackson. That's absolutely correct, because if a police officer does commit a crime, you know, and that criminal history is as public as everybody else's. You know, you're going to be able to get it on case search just like you can get everybody else's. And it's their personnel employment files that include disciplinary actions from internal affairs.
Yeah. And I have seen everyone raise their hand, so I'm gonna go to Miss Florence. Did you just lower your hand? It seemed like, or are you ready to go?
No, I didn't raise my hand, no.
Okay, Mr. Lottridge, all you.
Oh, God.
Good evening, Miss Joy.
Good evening.
I only have 3 questions. Each question has 17 subparts. So, I mean, I'm not gonna, my role in this particular setting is not my role as the public defender necessarily for the county. However, they certainly overlap. So I want to talk briefly with you, and I have a couple of things. One, we all agree there's an obligation to turn over impeachment evidence. Right now, from what you're saying, you don't have the access to know what is there that should be turned over, correct?
Do we have the access?
Yeah, I mean, do you know what's in?
We have limited access.
Okay, so when you,
Well, not access, I should say that. We have limited knowledge.
all right. So when a case is brought and officers are charging the case and officers are involved in the case, what is the process to vet whether or not there's something discoverable that you should be requesting?
So we have a relationship with the Office of Law. There is an individual over there who, you know, he used to work in the Baltimore City Public Integrity Unit. And so we have come up with a system with him in order to do a preliminary review. Okay,
so you reach out to this person. Does that person have access to the files?
Yes.
So they actually go in and look at the files.
They have access to all of the files. Yes. I don't want to say what he does. I know that he has access to everything. Yes.
I want to make sure I understand the process, because one of the first things you said is you're requesting more access, which I think, you know, I think the state attorney's office had made clear they don't believe they have the access. You don't have the access. You need to ensure that, you know, the full due diligence is being done. So there's clearly a lack of transparency somewhere. If that's the point at which you started, and that is the point at which you started, I think it's clear that everybody is worried you don't have enough, there's not enough transparency for you to see the records, right? So that's the reason I'm going there. So my question is, before I get to the next question, let me take a step back. You also said there's a county ordinance, essentially, that the County of Law, the Office of Law must object or deny all requests for records. Did I hear you say that?
Maryland rules.
I thought you said it was county, but is it Maryland rules requires?
I know, Sadia Noah Hope was referring to the county code. The Maryland rules of personnel records has deemed them privileged and confidential, and that the custodian must deny inspection.
So, I mean, it's automatic that the custodian, pursuant to Maryland rules, you're saying it's automatic the custodian must deny, and that's why you have to go.
Yes, must deny.
And that's why you have to go through a subpoena process, or is there any other process other than a subpoena process to get to the records that they must deny?
Well, the subpoena process doesn't really allow an avenue to examine records, like any personnel record that we want to examine, because like I indicated, if you do a motion to subpoena tangible evidence, you have a burden of showing that why there is discoverable information in that file. You cannot use the subpoena power to go into a personnel file as a fishing expedition.
Right.
So if you don't have reason to believe that there is not something in that file that is discoverable, then you can't in good faith file a subpoena.
And you don't have access to the file to find out if there's something in it that is discoverable.
I will say that I have enough access that if I need to do a subpoena in a certain case, I have a basis.
So you have.
I don't know whether or not how that has played out in court, but yes.
I guess my point is this, or my question and my point are this. There's this veil we can't pierce, because to get the subpoena, you have to have the knowledge of what's behind the veil. You don't have the full knowledge of what's behind the veil. What's in the filing cabinet? You don't know what's in the filing cabinet. To get in the filing cabinet, you have to tell the court, this is what we think is in the filing cabinet. So what is the process? So, I mean, is there any way around that other than legislation? And how do they get around it in other counties?
I can't speak for the only process I know or I've heard of that exists, and I really, like I said, I don't know I don't know, the process in which the system was developed. But what I understand in Baltimore City is that there was an agreement between the Solicitor General's office, which is my understanding is equivalent to the county attorney's office, but they have the Solicitor General's office and they had a court and the state's attorney's office entered into an agreement. And my understanding is that agreement allows for not only the state's attorneys to have full access, but defense attorneys to have access as well. So that's what I understand they have that system set up as. I can't tell you, what other jurisdictions have. I just know that something like this exists in Baltimore City. And I can't, and unfortunately, I wish I could tell you because I wasn't a part of it, but I'm not quite sure how that process came to be, but I do know that there's a signed agreement with the court and with the Solicitor General's office and the state's attorney's office. And I believe that the public defender there might have also been involved in that agreement as well, that has allowed them to do to get the kind of access that they are getting in Baltimore City. But that's not something that we have here in Prince George's. And, that's something, go ahead.
Ms. Joy, I know we don't have it, and let me be clear. I think you are trying. I'm questioning you, and for everybody here, we go a long way back, and she likes to bust my chops and
all the time.
And actually, she usually wins in these kind of, as she well knows. But what I want to really get to is, they do have an agreement in Baltimore City, and this committee is going to be making recommendations. And I don't think that agreement has anything to do with a piece of legislation. I think it's an agreement between the county, the court, and that's pretty much it. And the state's attorney's office.
Yeah,
so
it doesn't involve
I just wanted to clarify that particular point. That's what they did in Baltimore City. And from your knowledge or from Cydia's knowledge, is that a possibility here?
So can I step in? I'm back.
Okay. Yeah.
Yes, that actually is something that we have requested in our seeking. And I think it really is the will of, the administration to want to enter into such an agreement. I think it is important for access and transparency. And quite frankly, it is very cumbersome when we don't have that level of access. So I think it would be very important and helpful, not just to the Prince George's County State's Attorney's Office, but I can tell you that state's attorneys across the state, this is like one of the only things we can all agree on is the fact that we should have full access without, having to get court orders and this or that to these records, because we're not using the material for, public purposes, for information like for news. We're using it to determine whether or not someone, is credible. We're using it to determine whether or not we're going to move forward with a case. We're using we need it to determine whether or not we have things that we need to disclose. Now we are getting that information, so we are doing our job, but it is very cumbersome, and it would be a lot simpler if we could have such an agreement. Now we have certainly proposed it. We'll certainly propose it again. But if that's something that this work group is supportive of, then we are in full agreement with that.
Can I just ask a follow-up question, Madam State's Attorney? How long have you been requesting for that agreement, or how long has that been in the works?
Well, just more recently, and it really surrounded the lawsuit and the report that came out, the report of the expert in the federal lawsuit that accuses or alleges discrimination and bias in the police department. And it became more apparent to us that, number one, we needed the unredacted copy of the report, because we want to make sure that we understand whether or not there are individuals who may have cases in our office that have these claims, and whether or not we have to do further investigation to determine whether or not there's merit and we have things to disclose. And so it really has been in the last, I would say, a couple of months. I know that prior to that, we did ask for greater access, maybe about, I don't know, Renee, when would you say we first approached the department about providing greater access. Would you say that was 6 to 7 months ago?
Yeah, I think so.
Yeah.
We did have an initial conversation a while ago before that, but then, it came up again more recently.
Yeah, but more recently, I think our and we did provide the administration, I believe, and the department with copies of the agreement with that Baltimore City, the city solicitor's office has with the state's attorney's office, and we think it's a good model. So we hope that we can continue to have those discussions, because that's something that actually we could probably implement now.
Got it. Okay, well, that sounds also like a great recommendation from the work group as well. So
yes.
All right. Any other questions, Mr. Lottridge? Go ahead. I'm sorry.
Oh no. I was just waving goodbye to Renee, since I'm not going to bother her anymore. And
thank you.
Thank you.
Okay, seems like no problem. It seems like we all are about complete. I didn't see any more raised hands, so it seems like Ms. Joy, you answered everyone's questions so eloquently, and we really appreciate your time. And Madam State's Attorney, we thank you for joining on and being able to share your thoughts and concerns, and for introducing Mrs. Joy to us as well. And Major McCreary, although you took up so much time, man, we appreciate you as well. And if you can send us some of that data and be able to present it to the public, it will be great. Mr. Pastor Robinson, I see your hands up.
No, I saw Mr. Archie raising his hands. I don't think you saw him.
Did you have a question? Oh, I'm sorry, Mr. Archie, did I miss you?
He must have just left, but he was.
No, I didn't leave. I'm here.
Okay. You have a question? I'm sorry.
Yeah, this is dealing something along with Mr. Lottridge, what he asked, but this is dealing with an internal audit or outside auditing of the internal affairs. I don't know if the state's attorney office randomly audits internal affairs. They see how these cases, with 800 cases, we need to know how these cases are disposed of and who's doing the auditing of them.
Yeah, I don't believe that we have that authority. I believe that they have an inspector general at the police department, and I think any type of auditing, that function would be handled by that individual. And I think that individual's on this task force.
That's Mr. Turner, yes. Mr. Turner.
I didn't understand your question. What was your original question?
I'm asking about the auditing process for internal affairs. Who actually conducts the audit? Was it random? Was it?
That's not my. I've not been given that responsibility, so I'm not aware of an auditing function with regard to internal affairs.
Major McClure, can you answer that question? Because you had over 800 cases. How do you dispose of those cases? And
I don't know if I understand the question exactly. How do we dispose of?
Who conducts the audit?
When we have a finding in an instant, or like when we're going through an officer's history?
No, not the case itself. You have 800 cases that you said you look at. And you have to dispose of those cases at some point. Randomly, somebody should come through your process, I would think, and conduct an audit to make sure cases are being disposed of correctly.
Can I just reframe the question a little bit? Who within the police department conducts, or within the county government conducts audits of the internal affairs and ensures that you're following your own guidelines and procedures, and then releasing those documents wherever they need to go if they are disposed, if they reach a certain limit or reach a certain point? What happens after that point? I guess that's an overall question for the entire department as well. Who conducts an audit of the policies and procedures and ensures that you're following your own and state and county policies and procedures? So I know that's not particularly what Mr. Archie's asking about, but I feel like that's getting a little bit more close to me.
Yeah, that would be done again with the Inspector General in conjunction with the Chief of Police as well as Internal Affairs. We also have our Planning and Research Division that audits all our policies and procedures to ensure that they're up to date. I think that answers the question if I'm understanding it correctly, but yeah, it's all self-regulated from my understanding from within the police department.
Got it. Another thing I'll add, the CCOP does serve that function as well. All cases that are reviewed by the Internal Affairs Division are sent to CCOP for their review. So they're partly responsible for I guess, reviewing, auditing the cases that are investigated by Internal Affairs. I've never, I wouldn't call it an audit of the Internal Affairs Division, the cases that they've handled. I review a lot of different policies and procedures within the police department. There's just one of me. Okay, so it would be impossible for me to review each and every case that the Internal Affairs Division handled. And another entity that has that really sort of complements what the Internal Affairs Division does with regard to the more serious cases is the State's Attorney's Office, and Ms. Joy just talked to you all about that. So there's with regard to more serious matters that are potentially criminal, you have the State's Attorney's Office and you have CCOP. Occasionally, I may receive a case or a case may be brought to my attention. One of the things that I do, and I work with Major McCreary pretty much on a regular basis. They bring cases to me to ask for my input fairly frequently, but also I'm part of what's considered the chief of police executive team. So any case that in which an officer is charged, and with the more serious offenses, as Major McCreary talked about, once a decision is made with regard to the charges, that case is, as Major McCreary mentioned, that case is brought to the executive team that consists of the chief, the deputies, the assistant chief, and also myself. So I also cast my vote in terms of whether that case should be, whether that officer should be charged administratively, and also what specific charges, administrative charges that the officer should be charged with. So I'm part of the process at several different stages. I also participate in administrative hearing boards. I provide advice, legal advice to the board members, and also during the board hearings, I'm usually in the room observing them and providing advice as the hearings go along. So
thank you, Mr. Turner. We're going to have you come and present to us as you and I talk separately. So we really appreciate that information. I think that what I heard was that CCOP does the auditing for internal affairs, which kind of sounds weird because CCOP doesn't have the capabilities of issuing subpoenas, but they have the authority and they have the ability to issue audits or review audits of internal affairs. So if you guys can give us some additional information on that, because that does sound like something that they don't do, and who actually does do that, who actually does conduct the audits of internal affairs. I think that's important for us to know. So that
I'm sorry, Delegate Washington. I'm happy to come back as you and I communicated and talked about my role. But CCOP actually does have subpoena power. I believe that they indicated earlier, Ms. Felix Lawrence, that Lawson, I'm sorry, that they don't exercise that, or they haven't exercised
because they don't have they said it because they don't have the capacity to do
sure.
it. Is what
that's right.
And I'm saying if they don't have the capacity to issue a subpoena, they probably don't have the capacity to conduct an audit. Is what makes a little sense. Is what I was equating there. So it would be good to give some information on that. But I don't want to. We hit our mark. We're on a roll. Mr. Archie, thank you for bringing the stuff back up. Crystal, one question.
Okay, one question. You brought up again the administrative hearing boards, and they talked about how for us that they don't rotate. And so I was just wondering if that is a institutional rule or at the discretion of the chief of police, why those have been permanent.
It's actually the discretion of the police. It's my understanding that the police made that decision along with, it was an agreement between the chief and the head of the union, the FOP. So there are some police departments around the state that have rotating boards. There are a couple of, and those are the smaller police departments. So much smaller police departments tend to have rotating boards. The bigger police departments, Prince George's is one of the bigger police departments, Montgomery County. They have permanent boards. So what I found is that the larger police departments do tend to have permanent members. The smaller ones, because there are much fewer cases that are being brought, they tend to have rotating boards.
Thank you.
Thank you, everybody. Thank you.
I have a question for you.
Okay.
Logistical. When we are the original presentation with the police department, we never got through that. I think we stopped on slide 43 that started to go into statistical data. So I'm just curious, are they going to come back again to do that portion of their presentation?
Yeah, we can have them come back and do that part of the presentation. So hold us accountable for that. We'll make sure we do that. Next week, Judge Lemaski and I are setting the meeting. Judge Lemaski, I sent you a quick text message. You can check your text message for me. But we want to thank our two presenters on here. And Miss Joy, if you can give me some information about, of those 800, how many of those complaints actually come to you? Because he mentioned during this presentation that some of them, they don't want to give you too many. is what it was said. So if you can tell us how many you get on a yearly basis, that'll be good to know. Or of that 800 that he mentioned, how many actually has come to you? It'll be good to know. Judge, what do you think?
I think that's great.
Okay,
That's
so
perfect.
So next week, everybody, we're going to have a presentation from a few of our folks that are on our panel, actually, on the commission or the task force here, and I just want to make sure I get it right. So next week's meeting, we're going to have the Inspector General's office come speak to us and tell us what his roles are there, and then we're going to also have the Office of Law, who Miss Sadia Hope is working on, and Tara Jackson is working on to get us next week, and then we're going to hear from Miss Florence Felix Lawson from the CCOP on their progress. And I just want to let everybody know, like today was great. I think we all asked many great questions, and I think this has been a great process. And so we're going to keep it this way. I've sat on these commissions for a long time, many of them. And so I've had days where we had 8-hour meetings. And so obviously we're not going to do that here, but these meetings will go on long with or without you, because I feel like we need to have these presentations. So we'll have them. And I know everybody knows that we have an October 30th deadline as of now to present our recommendations to the county executive. So just keep that in mind too, as we are developing our recommendations. And so all the chairs and the co-chair and I have met this Monday. And so all the chairs will start having their meetings soon with all the members to discuss their roles and developing their recommendation and developing the recommendations for each of those work groups. So please be on the lookout for those times for when you're going to meet based on your particular work group as well. And you will be able to ask questions and get some of the some information from maybe Ms. Joy or Mr. McCreary that might be able to come and speak to you during those times as well, as long as it's ahead of time so they get an opportunity to do that. But either way, I want to thank you all. Judge Lemaski, do you have any final comments?
I wanted to thank everybody. I thought the presentations were fabulous tonight, as well as the questions. Did we want Ms. Joy to come back when the Office of Law comes back?
Yes, definitely. Thank you for that, Ms. Judge Lemaski. Yes, if you can come back next week, Ms. Joy, just to be able to give your perspective as well as the Office of Law perspective, because I think it'd be good. We would not like to have you both separately on that discussion. So we can make a great recommendation on what the two arguments or two sides are.
I thought it was great.
And maybe at that time we can come to an agreement because of this work group.
So that would be on the 27th at the same time?
Yes, ma'am.
Okay, I'll put it on my calendar.
Okay, thank you very much.
Thank you, Ms. Joy.
With that said, thank you very much, everyone, and we'll be back here again next week. Have a great one.
Thank you. Thank you very much.
Thank you. Have a good evening.
Thanks, Delegate.